You're watching Bill on Bankruptcy. I'm Lee Pacchia. I'm joined now, as always, by Bloomberg News bankruptcy columnist Bill Rochelle. Be sure to go read his daily bankruptcy column. It's available on BloombergLaw.com, and it's also on the Bloomberg Terminal. Bill, good to see you.
Good day.
Okay, so we're going to start off with our first item. And Bill, if it was something that we were writing a movie script for, we'd entitle today's case of the week as War of the Hedge Funds. The bankruptcy court in New York has a case that's like an irresistible force meeting an unmovable object. What's going on here?
Well, this is LightSquared. I mean, this is the most fun case there is right now by far. LightSquared's a very creative company. They spent $4 billion developing a satellite-based communication system for cell phones, basically, so that instead of reaching the local cell tower, you'd go up to a satellite. They were going to use frequencies that were adjacent to the frequencies used by global positioning satellites. Problem is, when they were getting close to the point of trying to implement the system, the FCC said, nope, sorry, can't do it. We made a mistake. It might interfere with reception by GPS devices, cause minor problems like aircraft crashing, things of that sort. So they ended themselves up in bankruptcy, and they are in a knockdown, drag-out fight. The principal player here is Philip Falcone's Harbinger Capital Partners. They had the great pleasure of buying the equity of this puppy for $1 billion about 3 years ago, and right now, of course, he's looking at a big goose egg unless he can pull this thing out of bankruptcy. On the other hand, you have a whole bunch of hedge funds who bought the debt, and there's a lot of it. Just for a company called LightSquared LP, there is about $2.1 billion of debt. These LightSquared lenders, as they are the LightSquared LP lenders, as they are called, lined up, of all people, Charlie Ergen's Dish Network to buy all of the assets for a cool $3.5 billion and enough cash to pay off those LP lenders in full. Meanwhile, Mr. Falcone is running around trying to find a way to keep ownership of his business. There are at present no fewer, I think, than 4 competing Chapter 11 filed, because that is plans filed, because dear old LightSquared has lost the exclusive right to propose a reorganization. Mr. Falcone's plan that he submitted on behalf of Harbinger, the owner, is rather interesting. He is going to, he says, pay off the $2.2 billion of bonds in full, but get this, Lee, by giving them new notes. Okay, well, that's often done. These new notes will pay interest ranging from 9 to 11%. Okay, that looks like a pretty good interest rate. Here's the kicker, however. The notes will pay interest not in cash, but with more notes, in other words, called PIK notes. Now, I won't say that that proposal is laughable, but I suspect that words to that effect will be used by the LP bondholders, who I don't think are going to cotton to the idea of taking PIK debt for $2.2 billion. This case is going first to a sale. We'll see if Mr. Ergen is a high bidder, or if somebody else shows up, or if Mr. Falcone can raise $2.2 billion in cash. In any event, there is no reason, if you like blood sports, to go to the bullfights or to go to dog fights. All you got to do is to go to bankruptcy court and watch LightSquared.
Right. And Bill, we've over the last couple months and years noticed this trend developing where unsecured creditors can recover something like 3%, even in cases where assets don't cover secured debt. I gather this practice might be coming to an end, at least in Delaware bankruptcy court. Is that what's happening in the LifeCare case?
Well, that is exactly right, Lee. Don't know if that's going to happen. The only person who knows right now is a district judge in Delaware called Sue Robinson. Here's what happened with LightSquared. This was an owner of a bunch of hospitals. They sold the hospitals to the secured lenders in return for debt. The unsecured creditors were raising holy you-know-what about the sale because they were not going to get anything. In a settlement, the lender said, well, listen, tell you what, we'll make a $3.5 million gift to the unsecured creditors. That money's going to be put in trust for them, can't go anywhere else. This was all hunky-dory except for the fact that there is a $24 million priority tax claim owed to the good old U.S. government. And guess what? The IRS lost in bankruptcy court, as you would expect they would. They didn't take it laying down. They are appealing. They are saying that in bankruptcy, you cannot ignore the distribution priorities by giving money to unsecured creditors when priority claims that should come first are going to go begging and not receive a dime. This is essentially the issue that Judge Robinson is going to have to decide in the next few weeks. How it comes out, Lord only knows. I do know, however, that if she finds that you must follow the rules of priority, it means that many cases now where unsecured creditors get small distributions, they're going to get zip. If that should be the result in Delaware, probably might be followed in New York as well. At that point, I think only Congress can step in and do something, because if you have to strictly follow the priorities, it means that unsecured creditors, more often than not, will get nothing, and bankruptcy reorganization will become the playground exclusively for secured creditors. I'm not sure that's what Congress meant, but that's very well possibly the way the law is going to be interpreted.
Right. And we finally have a new bankruptcy case of considerable size. It's Longview Power. They're the owner of newly built coal-fired plants in West Virginia. Bill, what's going on there?
Well, this is an example of how you probably couldn't have had worse timing if you'd tried. They built a state-of-the-art coal-fired electric power plant, I think 700 megawatts. They built it at just the wrong time because electric prices went down and natural gas prices went down, putting coal-fired plants at a distinct disadvantage. They spent about $2 billion building this state-of-the-art facility. It has a lot of new technology, but unfortunately doesn't work terribly well. They have so far only been able to make the thing produce at about 68% of capacity, so as a result, they are losing their shirts. They found themselves in Chapter 11, as you can imagine, because they were unable to service a whole lot of debt. And the outcome of this case very well may depend upon who bellies up to the bar and pays basically for damages or fixing up this plant. There are lawsuits pending, or will be pending, or arbitrations against the people who designed and built the plant. And they might be the ones who end up paying the cost here, if in fact it's their fault, but who knows what it is. In any event, this is a good old-fashioned bankruptcy.
Yeah, something we haven't seen in a while.
Correct.
The Court of Appeals in San Francisco did something rather unusual last week. It reversed itself on an important issue in consumer bankruptcies. Bill, what's the precise issue at play here?
Well, again, as we often say in these advance sheets, if you are a bankruptcy nerd, especially a consumer bankruptcy professional, stay tuned. Otherwise, you can go about your business right now. Mm-hmm. This is from that marvelously creative court in California called the Ninth Circuit Court of Appeals. They were out on a limb with a decision that nobody else was following. It was a case from a couple of years ago called Manny versus Kagengama. There were two holdings in the case. One of the holdings, they were split with other circuits. On that issue, it went to the U.S. Supreme Court, and the Supreme Court reversed them. There was another part to this decision, too, which said that in Chapter 13, if you are the kind of a debtor who does not have disposable income, then your Chapter 13 plan does not have to be 5 years. The Ninth Circuit was okay with it being as short as 3 years. Two other circuits disagreed. Well, and for that matter, so did Circuit Judge Susan Graber, who was on a panel of three who decided this thing about a year ago right now, allowing a 3-year Chapter 13 plan. The losing side made a petition for rehearing en banc. The en banc argument was held, and guess what? 11 judges unanimously reversed their own three-judge panel from the year before and held that in all Chapter 13 cases, the plan must always be 5 years. I was, soon after this case came down, talking with a judge friend of mine, and this judge said that this latest case from the Ninth Circuit is another example of how courts are interpreting the 2005 amendments to the Bankruptcy Code to mean that Congress intends for consumers to be basically punished if they try filing Chapter 11, or Chapter 13.
All right, Bill, thanks for that. That's Bloomberg News bankruptcy columnist Bill Rochelle. If you'd like to learn more about the cases and issues we just ran through, be sure to go check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. You can see more of our videos on YouTube. You can follow our updates, of course, on Twitter. I'm Pacchia. Thanks for watching.